The docket will begin momentarily with the playing of the Advice of Rights and Information video. Please take a moment to label yourself in Zoom with your first and last name so we can get you checked in. If you do not know how to do that, but you can work the chat, you can put your name there and we will label you accordingly. Please remain muted and wait for your case to be called. When your case is called, please turn on your camera, unmute, and state your name. Thank you.
Welcome to the 14th District Court. I'm the Honorable JudgeSimpson. And I'm about to provide to you valuable information regarding this current and other landlord-tenant agreements. This is the landlord-tenant summary proceedings document, and you are here for a retrial. Your landlord has made allegations or claims that you should be evicted because you have not paid your rent or because they seek termination of your tenancy or lease violation. After today, you will come back for an additional hearing or trial of the case unless you and your landlord reach some agreement. In these proceedings, you have the right to have your case heard in the proper venue. 14A District Court is located in Simpson Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and its Lundy Township is covered in this court. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at the first appearance or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. Rental assistance. In 5 days of first receiving these advice, rights, and information, you must provide written proof to the court that an application for assistance has been submitted for processing. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mich.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as TAUNTS. TAUNTS can be reached at their phone number, area code 734-961-1999. Additional assistance is also available to the Washington County Veteran Services. Their phone number is area code 734-973-4540. Also, you may obtain housing assistance and other resources through the coordinated entry resources. Their phone number is 734-544-6748. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside court. Michigan and local community dispute resolution programs are a possible resource. The Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-2125. To protect your credit and future rental possibilities, your case may be resolved by way of conditional dismissal in lieu of a judgment, if that is approved by all of the parties and the court. It is important that you understand these rights. If you have any questions, please feel free to address the court during your hearing.
The 14A District Court is now back in session. The Honorable Judge J. Cedric Simpson presiding.
Thank you. Riverside Apartments versus John Wilkerson, and good morning, everyone. I'm sorry for not reading you. John Wilkerson and Joshua Wilkerson.
John Wilkerson present, Your Honor.
All right. Mr. Fink, where are we on this?
Your Honor, it's a termination case. And as the court knows, it was adjourned last week.
Mr. Wilkerson's case was adjourned.
I'm sorry, Your Honor. I've got a. Could you pass this, please?
All right. I'll pass the matter. All right.
Thank you.
We'll get right back to you, Mr. Wilkerson, shortly.
Yes, sir.
The Haven versus Marshawn Brooks.
Not checked in.
James Fink for the plaintiff.
They are not here. If you'd like to take a default, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead, sir.
Your Honor, this is an action for non-payment of rent. This defendant owes $1,791.45 in rent. The costs are $175 for a total of $1,966.45.
Judgment to the plaintiff. That is by default for possession, redemption amount in the amount requested with the writ issue in 10 days. And the Haven versus Nikki Hess, that matter is dismissed on plaintiff's motion.
Thank you, Your Honor.
Let
I'll
me
be right
know-
back for Mr. Wilkerson.
All right, fantastic. Arbor Meadows versus Rachel Cox.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of Arbor Meadows.
Good morning, sir. And Ms. Cox?
I'm here, Your Honor.
All right. This is a termination of tenancy action. Plaintiff's claim in the case.
Plaintiff's claim, Your Honor, is that Ms. Cox's dog bit a guest of another resident. Pretty severe bite to the right hand. Police were involved. The dog ran loose.
All right. Ms. Cox, what's your position on this?
I have several, actually. My dog is not aggressive whatsoever to kids, humans. It doesn't matter. She is very friendly. The only reason why she bit was because he tried to restrain her and grab her collar, and she was scared.
Was, well, where did I don't think there's a dispute that the bite happened. Where did it take place?
It happened in our neighborhood, in Arbor Meadows.
Okay, so it was in the neighborhood?
Yes.
Okay. Who, was the dog leashed or?
She was outside, and a neighborhood kid has been letting her off, and she got loose because someone let her off.
Okay. All right.
Your Honor,
So,
the
ma'am, are
dog,
you,
the dog was loose. It went after another dog. The victim tried to separate the two dogs and was bit.
okay, that's it. Okay, I got you. Okay. What, ma'am, are you going to have an attorney in this matter? How are you intending on proceeding in this case?
I don't have an attorney, no.
All right. So here's what I'll do is I'll adjourn it out for you to try to seek some legal counsel on it, regarding the termination. In our video, there's the Michigan Clinical Law Program, as well as, legal services that you can contact us, as well as, the Washtenaw County Bar Association, to see if you can get, representation regarding this issue. Okay.
Okay.
And then we'll figure out how we're going to proceed. I would adjourn the matter to November 7th, 2025 at 12 noon. All right, that's an in-person hearing, ma'am, so you'll have to be at the courthouse in person, all right?
Okay.
Okay, thank you. We'll see you then.
Thank you.
Court calls case of Beal Properties versus Callaloo Jackson.
Daniel Landman, Your Honor, on behalf of the plaintiff.
Jackson, are they here?
No, here.
They are not here. If you'd like to take a default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Go ahead.
Thank you. Your Honor, Mr. Jackson leases the garage unit at 509 North River Street Garage in Ypsilanti. It is a month-to-month lease. Mr. Jackson was provided with 30 days notice and has failed to surrender the unit. That's why this action was filed. He is not present. We would request that a possession judgment enter terminating the tenancy as to this particular garage.
Plaintiff, that is by default for possession. No redemption amount, writ issue in 10 days.
There's no, yeah, Your Honor, there's no redemption amount as a determination action.
Yeah, no, I said that.
Okay,
No redemption.
I misheard. I'm
No
sorry.
redemption, writ issue in 10 days. Westridge Mobile Home Park versus Michelle Cates.
Daniel Landman for the plaintiff.
Not here. I don't have one minute. They are not present. You may proceed, sir.
Your Honor, they're not present because they satisfied their rent arrearage this morning. Plaintiff moves to dismiss without prejudice, and we will be submitting a dismissal.
All right, fantastic. That's why they're not here. Good explanation. All right, Westridge Mobile Home Park versus Wells and Westridge Mobile Home Park versus Beverly. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a great weekend.
You do the same, sir. And back to Riverside Apartments versus John Wilkerson and Joshua. Mr. Wilkerson is present. Mr. Fink?
Thank you, Your Honor. So it is a termination case, but it's a health hazard termination case. And technically, this is the first hearing. Mr. Wilkerson, of course, was scheduled for last week. This is an issue of the overwhelming pet odors in the building affecting other tenants in the building. Feces on the floor near the kitchen. I don't need to go over everything on
Got it.
on Zoom, Your Honor, but we would like the tenancy terminated. We also filed a 1-month lease violation notice to quit also on October 3rd. So next week, if we don't have a resolution, we'll file an amended complaint so that this is both a health hazard and a lease violation termination.
Got it. All right, Mr. Wilkerson, what's your position on this, sir?
Yes, sir. I'm moving. I have a new place secured as of November 7th. I just request a couple weeks' time to be able to move and clear out the unit.
Well, here's what I'm going to do. I'm going to adjourn this out 1 week to November 7th, 2025 at
3 p.m.
3 p.m. That's an in-person hearing. What I'm going to suggest to you is you contact Mr. Fink's office and try to arrange the time frame for you to vacate the premises, okay?
Yes, sir.
All right.
Your Honor, 2 things.
Yes, sir.
Would the court please, for the ROA, note a default for Joshua Wilkerson, just in case we don't have him show up? And
yes, for Joshua defendant 2. Yes.
Could we give Mr. John Wilkerson advice regarding MCR 4.201J so that if he and I can enter into a COD for him to surrender possession, he won't have to come back?
Mr. Wilkerson, if there's a procedure by which there wouldn't be a judgment, but you would be consenting to move, as it seems to me that you are, there would be a conditional order, what's called a conditional order of dismissal, that may be able to be worked out. And if it gets worked out, you would not have to then come back after you sign it or give permission to have it signed. You understand that, sir? All right. So if that can all be worked out, I'm going to advise you of certain rights. And that is that within 3 days of my signing of that, you have the right to think about it. And if you believe that there's some legal confusion or some legal issue, some confusion on your part, some mistake on your part, or some right you didn't assert, you'd have those 3 business days to file a motion with the court to ask that be signed. You understand that, sir?
Yes, sir.
Okay. So you can enter into the agreement, long and short of it, you can enter into the agreement, but you have time to think about it after you've done so, okay?
Understood, sir.
All right. Okay. November 7th, 3 p.m. All right.
Yes, sir.
Thank you.
Thank you, Your Honor.
Thank
Thank
you.
you. That's it? That's it for that block? Wonderful. We're done till
noon.
Nope, I'm not coming back in there. I've got lunch. Am I going to get lunch? You guys need to feed me. All right. Court is staying in recess.